My name is Rachel Rodriguez, and along with JC Matthew, Amanda Graybill, and Christina Ordina, we prepared the Mental Health Parity and Addiction Equity Act. For today's presentation, we will start off by summarizing and giving a brief history of the Mental Health Parity Addiction Equity Act. We will then go into non-quantitative treatment limitations, partial hospitalization and residential treatment, enforcement of the Mhpaea, and finally we will conclude with some cases and a brief overview of everything that we talked about today. What you see right here is a timeline of the Mhpaea, and just going forward we are going to refer to the Parity Act as the Mhpaea to save some time. In 1996, the Mental Health Parity Act was made available for mental health benefits only. It was also only offered by group health plans. In 2008, the Act became widened to include addiction as well, which is why it's called the Mental Health Parity and Addiction Equity Act. It was also made so that the mental health or addiction disorders were in the same terms of limitations and coverage as compared to regular surgical and medical benefits. In 2010, the Mhpaea was increased to alternative Medicaid plans. In 2013, private health insurances adopted the Mhpaea. Finally, in 2015, to the rest of the Medicaid population. This is a timeline of the Mental Health Parity Addiction Equity Act. It starts off in 1996. In 1996, the mental health parity was made available for mental health benefits only. It was only offered by group health plans. In 2008, the Act became widened to include addiction as well. It was also made so that the mental health or addiction disorders were the same in terms of limitations and coverage as compared to regular surgical and medical benefits. In 2010, the Mhpaea was increased to alternative Medicaid plans. In 2013, private health insurances adopted the Mhpaea, and finally in 2015, it was widened to include the rest of the Medicaid. The Mhpaea is a federal act that mandates that when coverage for medical services is provided, then coverage for mental health and substance abuse services must also be provided. The mental health services must also be at the same level as those benefits that are granted for medical and surgical. Mhpaea makes it illegal for an insurance company or employers to cover medical surgical procedures but not mental substance use disorders. If coverage is provided for one, then the coverage for the other must also be offered. It is important to have such a rule because for a long time, mental illness was not seen as important as physical illnesses, even though millions of Americans suffer from them. Mhpaea holds different protections such as financial requirements, treatment limitations, out-of-network coverage, reasoning upon denial of claim. The Mhpaea went from applying only to group plans to include individual health insurance coverage in 2010 by the Affordable Care Act, also known as the ACA. The goal of non-quantitative treatment limitations is to remove the option to impose limits on mental health and substance use disorder benefits unless the same exists for medical health problems. After the Mhpaea went into effect, insurance companies had to make sure that everything that applied or didn't apply to medical issues also applied or didn't apply to addiction mental health issues. Some areas that had to be addressed included prior authorization, medical necessity criteria, provider network admission. Authorization is a process whereby an insurance company reviews the benefits available for a customer or member along with the clinical information received from the physician. When the benefits are available and the clinical information sufficient, a determination, authorization, or denial is issued. Protections by Mhpaea required that mental health services coverage should not need unnecessary prior authorization that wasn't also required for physical illness treatment. There are thousands and thousands of services that may be performed, and insurance companies need to utilize their resources efficiently so that prior authorization is not going to be required for 100% of the potential services. Algorithms that take into consideration a number of factors that are measurable and repeatable help insurance companies decide what should or should not require prior authorizations. For parity purposes, an objective and measurable process needed to exist and be applied to both medical and behavioral services. Medical necessity criteria is accepted healthcare services and supplies provided by healthcare entities appropriate to the evaluation and treatment of a disease, condition, illness, or injury, and consistent with the applicable standard of care. When individuals are dealing with a complex medical condition that may require hospitalizations, continued stay review may occur. Typically, case managers from the insurance company outreach to the hospital to see how the patient is progressing. This may lead to additional approved days in the hospital. For mental health parity purposes, insurance companies had to make sure national guidelines were referenced to evaluate the need for additional services for both medical and behavioral. On the medical side, health insurance providers and hospitals typically use guidelines that are published by MCG. For those who may be asking, MCG is not an abbreviation for anything, but is a company. For behavioral, typically guidelines available from a number of professional organizations such as the American Psychiatric Association are referenced. American Society of Addiction Medicine are considered national standards. If insurance companies utilize national recognized guidelines versus homegrown, then parity existed. Under Mhpaea, if the health insurance provider utilizes best practice and evidence-based tools and applies them consistently, then process for conducting continued stay reviews for medical and behavioral necessity are considered to be in parity. Having a sufficient number of providers, including specialists, to meet the access needs of the customers that the insurance company is providing coverage for. Mhpaea sought to make sure that the insurance plan had processes in place that would equally allow a medical or behavioral patient into the network. Network adequacy is very important in ensuring that patients seeking behavioral services have a sufficient number of providers within the network to access. Most states, per state license requirements, have access requirements. At regular intervals, the health insurance companies must conduct studies to identify the number of any types of providers that are available in relationship to zip codes. Ratios are determined, and if the ratios do not meet requirements, then recruitment of providers occurs. This information is used by health insurance provider to determine who will be in network and must be the same for medical and behavioral patients. Partial hospitalization is a non-residential treatment program that is hospital-based. The program provides diagnostic and treatment services on a level of intensity similar to an inpatient program, but on a less than a 24-hour basis. Residential treatment programs provide intensive help for patients suffering from emotional, behavioral, or substance abuse problems. While receiving treatment, patients live in the facility where they can be supervised and monitored by highly trained staff about 24/7. Once a behavioral patient has made it past the acute stage of treatment, then they may not be ready to go home, or they may need additional services in either partial hospitalization or a residential treatment facility. Prior to the Mhpaea, these step-down treatment settings needed to be available to this patient population, driving the changes in requirements. Before the Mhpaea came into play, employers would request that the insurance companies carve out the needed benefits to reduce costs. Now, with the enforcement of the Mhpaea, this option is no longer available. Partial hospitalization and residential treatment is an important part of the Mhpaea. Because many situations that have to do with the mental health and addiction disorders may only get better if the patients are given continued treatment. There are a couple important cases that we will talk about during this presentation. They include BD and SD versus Blue Cross Blue Shield of Georgia, Joseph and Gail F. versus Sinclair Services Company, Natalie V. versus Healthcare Services Corporation, and Kraft versus Healthcare Service Corporation. The BD and SD versus Blue Cross Blue Shield of Georgia case is an administrative appeal of defendants Blue Cross Blue Shield of Georgia's denial of benefits for plaintiffs and is governed by ERISA. The plaintiff sued Blue Cross Blue Shield of Georgia after the plaintiff's claim was denied by their insurance company. Plaintiff is a particular in the employer's plan and his daughter is a beneficiary. His daughter received mental health care and treatment at UNITA Academy, residential care facility in Utah between August 8, 2013 and November 12, 2015. UNITA requested approval for coverage of services provided from August 8, 2013 through July 17, 2014, and the insurance company initially denied coverage, indicating that the requested services were not a covered benefit. The plaintiff administratively appealed, but the insurance company upheld its previous decision. The plaintiff then decided to sue the insurance company as a last course of action. The courts determined that the plan itself did not violate the Parity Act, but the insurance company's interpretation of the plan violated the Parity Act. and at the time the employer, Atlantico Ventures Inc., was dismissed from the case. Gale F. versus Sinclair Services Company, in its decision, which reasoned that if a plan is going to cover treatment received at a skilled nursing facility, which provides only medical and surgical treatment, then the Parity Act requires the plan also cover treatment required at a residential treatment facility, which provides only the mental health and substance abuse disorder treatment. Moreover, skilled nursing facilities were the equivalent to residential treatment centers prior to the final rules of the Act being issued. In the Joseph and Gale versus Sinclair Services Company case, the plaintiff's daughter, a minor, had suffered from serious mental, emotional, and behavioral health conditions. In early 2012, she spent 6 weeks at an acute psychiatric hospital in Texas for a suicidal ideation. The Texas facility procedures inpatient treatment to adolescents and adults with complex mental health conditions. Before discharging her, the staff of the Texas facility recommended that she receive long-term treatment in an all-girls facility. The staff warned that placing the plaintiff's daughter in an inappropriate facility for her needs could worsen her condition. The staff therefore recommended a program similar to Moonridge Academy or New Haven Residential Treatment Center. Both programs are non-network facilities in Utah. Following those recommendations, the family admitted their daughter at Moonridge on May 23, 2012. Moonridge is a licensed residential treatment facility in Cedar City, Utah. She received treatment at Moonridge until September 7, 2012. After Moonridge discharged her, the family admitted her at New Haven, a licensed residential treatment facility in Utah County, Utah, until March 1, 2013. The insurance company denied the plaintiff's claims on 3 separate internal appeals that her stay in the residential treatment center wasn't a covered benefit in one denial and that it was non-network in the other denials. The heat of the dispute is whether the administrator misinterpreted the meaning of area with regards to the network and availability of residential treatment centers in the area of Utah. The court concluded that the plan's residential treatment exclusion was a violation of the Parity Act. Another case cited in the Blue Cross Blue Shield case is Natalie versus Healthcare Service Corporation. The Northern District of Illinois thoroughly reviewed the Parity Act and wrote an organized, well-reasoned, and articulate order, which is the basis of the decision in the Blue Cross Blue Shield of Georgia case. The facts of Natalie v. are similar to the Blue Cross Blue Shield case in that the plan covered services received at skilled nursing facilities. However, the plan in Natalie v. categorically excluded coverage for mental health benefits at residential treatment centers. BD's plan was excluded coverage for residential treatment centers unless required by the covered by law, while Natalie v.'s plan had no reference to law. In the Natalie v. versus Healthcare Services Corporation case, it was decided that the Parity Act required the insurer to cover plaintiff's residential treatment for her mental health issues. Natalie v.'s claims were incurred in 2014 when the interim final rules, not the final rules, were in place. The insurance company argued that the final rules contain a new provision established that skilled nursing facilities for a medical surgical condition are analogous to residential treatment centers for mental health, but the court in Natalie v. case stated the final rules only confirmed what group health plans had already determined, namely that residential treatment centers are the mental health counterpart to skilled nursing facilities. Because the plan in Natalie v. had no clause subordinating its exclusion to the law, the plan in Natalie v. had held to violate the law. But the plan at issue here is expressly subordinate to the law, while Natalie v. held requires coverage for residential treatment. The court agreed. Elizabeth A. Kraft versus Healthcare Service Corporation. Plaintiff Elizabeth A. Kraft is an employee of Trustwave Holdings, Inc. and a participant in the Trustwave Holdings, Inc. Healthcare Benefit Plan. The defendant, HCSC, operating as Blue Cross and Blue Shield of Illinois, administers and insures the plan. Doctors have diagnosed Kraft's 16-year-old daughter, plaintiff Jane Doe, with post-traumatic stress disorder, recurrent, severe major depressive disorder, and anorexia nervosa. Since August 2012, Jane had been hospitalized 9 times for acute inpatient care to treat her mental illness. On each occasion, Jane's treating physicians have recommended that she be transferred to a long-term residential treatment center upon discharge from the hospital. On July 17, 2014, HCSC denied Kraft's request to pre-authorize residential treatment pursuant to an exclusion in the Trustwave plan. There was no corresponding exclusion for treatment of medical and surgical conditions in similar residential facilities. The court declined to limit the Parity Act and regulations to quantitative limitations only. The residential treatment center exclusion in the healthcare benefit plan prevented beneficiaries, like plaintiff's daughter, from receiving 24-hour supervision and care in a non-hospital setting, and there was no corresponding limitation on the treatment of medical conditions. Assuming that the term treatment limitations was not limited to quantitative limitations, plaintiff had stated a claim for relief under the Parity Act. The court denied the plan's administrator's motion to dismiss ruling in favor of the plaintiff. The Obama administration made parity a priority and, by creating the task force, acknowledges that parity is only meaningful if health plans are implemented fully and consumers and providers understand how it works, and there is appropriate oversight and enforcement. Between March and October 2016, the task force gathered information from stakeholders on many issues, such as barriers to parity implementation and enforcement, defining parity compliance, documenting parity violations, identifying mental health and substance use disorder workforce issues, documenting specific treatment limitations that may not comply with the parity, clarifying the role of states and the federal government in bringing about parity, and numerous other topics. The task force, led by the Domestic Policy Council, was charged with reviewing progress to date, identifying and taking immediate steps as warranted, and outlining future recommendations as summarized as it works for the final report. HHS has direct enforcement authority with respect to the Mental Health Parity and Addiction Equity Act over group health plans for employees of state and local governments. In accordance with the statutory requirement and to promote awareness and understanding of parity protections, the Department of Labor produces biannual reports to Congress. DOL has enforcement authority over private employer-sponsored groups' health plans that are subject to Mhpaea. The Employee Benefits Security Administration is specifically responsible for those investigations. The task force recommended that Substance Abuse and Mental Health Services Administration, an agency within HHS, host 2 state policy workshops on parity implementation for state officials in 2017. One of the workshops would focus on advancing parity compliance in the commercial market, and the other would focus on parity in Medicaid and the Children's Health Insurance Program. These parity policy academics are intended to help bring together national experts to conduct technical assistance for teams of state officials on strategies to advance parity compliance and best practices from other states' implementation efforts. As you can see in the pie chart above, taken from the final report of the Mental Health and Substance Use Disorder Parity Task Force, they show the types of violations found by the DOL. In this pie chart, there are lifetime dollar limits, annual dollar limits, non-offering benefits in all classifications, quantitative treatment limitations, cumulative requirements, non-quantitative treatment limitations, and disclosures to participants. This shows just how many violations that the DOL has found. The DOL has enforcement authority over private employer-sponsored group health plans that are subject to Mhpaea. From 2010 to 2015, DOL's Employee Benefits Security Administration closed over 3,000 civil investigations of health plans. Of those, 1,515 were subject to the 2008 Parity Law and therefore were reviewed for compliance, which resulted in citing 171 violations. In conclusion, the Mental Health Parity and Addiction Equity Act was not created or require insurance providers to offer for mental illnesses or substance abuse illnesses, and it does not require plans to cover specific treatments or services. However, the coverage that is offered for mental health and substance abuse disorders is required by parity to be equal to the coverage that is already offered for medical and surgical health conditions. The Mental Health Parity and Addiction Equity Act is an important first step to ensure that employers looking to reduce healthcare costs by attempting to eliminate these services understand the need for them and why suffering from mental health and addiction issues deserve equal coverage for care. In addition to the participant litigation risk posed by plan exclusions, a violation of the Parity Act can expose your company to a tax liability of up to $100 per day per violation. With the heightened focus by the Department of Labor and in litigation on the treatment of mental health services under employee-sponsored plans, companies' self-funded plans must ensure the exclusions and treatment limitations comply with the Parity Act. These are our sources that we use throughout the presentation, and we hope you enjoyed watching our presentation. If you have any questions, please be sure to ask us in the discussion board or email us. Thank you.